Well, good morning, everyone. I have some PowerPoint slides, so hopefully we will have an exciting, you'll have something visual to look at. I find that when we talk about law, if you don't give people some sort of reprieve, the audience starts hurting themselves. So I am a practitioner. So I'm not a scholar, I'm not a law professor, and I think it makes me a good candidate for holding something called a workshop, because I do things. I mean, just like anybody, a person who tinkers in a workshop to build things, we have to draw on, the knowledge of structural engineers. We have to draw on the knowledge of architects. But when it comes time to put something together, to build the building, to build the whatever it is, you have to call on the people who actually do something. So that's me, a practitioner. And if I have one message, it's that, as a practitioner, I view the Copyright Act as something of a steampunk law. Something filled with Rube Goldberg type contractions, and it turns out, by the way, that Rube Goldberg was a cartoonist, a sculptor, an inventor, an author, an engineer, so it might be fitting to call on his work. But, there was an article in Sunday's New York Times in the travel section about cruises, and they mentioned a steampunk cruise. So I think the definition of steampunk has pretty much fallen into common parlance, but it is a kind of a genre of science fiction or speculative fiction. It involves anachronistic combinations. And when I went looking for images just to get us all on the same page about what is steampunk, what image is in my mind when I say that, it turns out that a couple of years ago, the Funny 40 Fellows, all dressed up in steampunk style, and that's them standing in front of the streetcar. And it dates back to really the turn of the 19th into the 20th century, that sort of style, which is illustrated on that would be your left. And that whole movie, The Voyage to the Moon, was made famous in Scorsese's film, Hugo. So I think it's a lovely aesthetic, and as a copyright practitioner, I often think about that because, there's a contradiction. You have, old technology doing modern things, like, taking a bullet ship to the moon, using steam to get, into outer space. It is an obsession with technology, and that's a big part of copyright law. And it also envisions an alternate universe. That would be, works like The Wild Wild West, or the work of contemporary director Joss Whedon. So it just seems to fit with me about that is the state of our copyright law. It is an alternate analog universe in this very digital world that we live in. So the next thing I'd like to do is just get us all on the same page about what is intellectual property. And the definition I'm going to use is by the World Intellectual Property Organization. It's a treaty organization. The United States is a member. And intellectual property means creations of the mind, inventions, literary works, motion pictures, as well as the kinds of properties that we use to identify products. So it falls into essentially two categories: industrial property, and that would be patents, trademarks, industrial design, things called geographic indicators of origin, which are more prevalent around the world than they are in the United States, because we haven't set up a legal regime for that. But when you get certified wine, or you get Parma ham, those come with with a seal that tells you where they come from. That's all industrial property. The other big category is copyrights. And that covers all of our artistic works, poems, plays. It covers software, it covers broadcasting, and that's what we're going to talk about today. I also want to mention that there are a couple of categories, I'll call them extra definitional types of intellectual property. That would be trade secrets. This is information that gets its value from not being publicly known. That the most famous example would be the formula for Coca-Cola. But I also think of related rights, like media rights. This would be the rights of publicity and the rights of privacy, and those are often come up in the context of working with other types of intellectual property. So they don't fall under this WIPO definition, but there are areas of law that we need to be aware of. So when I say that the copyright law is anachronistic, it's an alternate universe, I want you to know that I'm not alone in my opinion. The Register of Copyrights, and that is the Register of Copyrights is the head of the Copyright Office. That's her title, Register. And she has recently testified before Congress that the current copyright statute was drafted to address analog issues and to bring the U.S. into harmony with international law. She says that the long trajectory defeated any hope that we could have an effective Copyright Act in the 21st century. One of her predecessors described the current copyright law, which was passed in 1976, as a very good 1950s statute. So whether it's me thinking steampunk or Barbara Ringer thinking about the 1950s, the Copyright Act is not of our time. So we're going to get started. I'm going to do the workshop in 4 parts. In the first part, we'll call them chapters since this is also a literary festival. And our first chapter is wherein we define the basics of copyrights in the 21st century. Okay? This isn't going to be a complete tour of all the provisions of the Copyright Act. It takes a little bit longer than our time today to do that, but we do need to get grounded in what we mean by copyrights. And the first thing we're going to do is we're going to start with the statutory definition, the subject matter of copyrights. And it's a nice, succinct definition, and every single word in that definition is important. Copyright protection subsists in original works of authorship fixed in any tangible medium of expression now known or later developed from which they can be perceived, reproduced, or otherwise communicated. Okay? It's a pretty understandable set of words. The statute gives a number of examples: literary works, musical works, dramatic works, pantomimes, choreography, the visual arts, sculptures, graphical works, motion pictures, and sound recordings. It's important that you understand that there are certain types of works that are extremely valuable, but they don't qualify for copyright protection. And that is, copyrights, and this is a very crucial distinction, copyrights protect expressions of ideas. They do not protect the ideas. They don't protect facts. They don't protect methods, systems, concepts, principles. No matter how valuable that may be, that is not afforded copyright protection. We also do not grant copyright protection to works by the U.S. government and its employees. They are our civil servants, and their work belongs to all of us. We don't protect useful articles, and that's sort of a judge-made rule. And that comes up in the fashion world where, because clothing is useful for very obvious reasons, it is deemed not to be protectable under the Copyright Act. And designers get knocked off all the time, and it's one of the many topics that Congress has been investigating. Do we need to give some type of protection there? The other thing that is important about this definition is there's no